This is in response to Lawrence O'Donnell's segment last night on MSNBC. I believe it's any more resignations in Fergunson. And Lawrence goes back to what he talked about last week, is that the assistant prosecutor, Kathy Azala, whatever her name is, I can't remember it exactly, right? She handed the grand jury piece of paper. It said this is the statute that you base your decisions on, based on whether or not Officer Wilson had the right to do that. That was the wrong statute. That statute was written in 1979. It was declared unconstitutional in 1985 by the Supreme Court. Was there bias on her part? Was there unprofessionalism on her part? Did she make a stupid mistake? And I'll get to that in a second. But so let's just take on a couple of things. Number one, Lawrence did talk about how the fact that New York Times did do a look at all of the questions that were asked of Darren Wilson when he was in there for his 4 hours, and of the other witnesses, and that it seemed to the New York Times that when Darren Wilson was asked questions, they were softball questions. They were easy to answer. They didn't hone in on anything. And then when they brought the witnesses in, the ones that agreed with Wilson, they just let that fly. And the ones that they disagreed with, they came down as being exceptionally skeptical. So they rarely did they ask anything really tough of Darren Wilson. But again, as I said before, the fact that he even showed up there, whether he had a lawyer or not, meant that the fix was in, because any good lawyer would say, don't ever appear before a grand jury. You never tell them anything that they don't want. You never tell them anything. Let them figure it out whether or not you did anything wrong or not. So let's get back to Kathy Azala. So she gives him the sheet. It was a wrong statute from 1979, invalidated by the Supreme Court in 1985. My question is, where did she get that from? What's their filing system like? Did she have to physically go into a folder and say, okay, this is the statute in terms of reasonable doubt? No, I won't say reasonable doubt. What is the statute that defines whether or not an officer has a right to discharge their firearm? Blah, blah, blah. They know what that is. They deal with that all the time, right? I don't know how long she's been around there or something, but where did she get that from? And the most important question is, after they've been doing that for 6 weeks, how is it that she or someone else on the staff found out, oh, we gave him the wrong statute. We need to give him the one that's up to date. And then, of course, her explanation wasn't worth the rat's ass. Or she says, don't worry about this. It has some little changes in it, but you don't have to really worry about this. And then the other assistant DA, I don't remember her name, basically says, we don't want to get into a law discussion. But my point is, if they found out that they had given the wrong statute, and, well, of course, to them, there wasn't any difference between the two statutes. One was, either way they were to get Wilson off, see, so that part of the fix was in. But, I mean, if they were professional, if they didn't have a bias, let's just say, they could even say, hey, we need to just get rid of this grand jury, tell everyone we made a mistake, and panel a new grand jury and get started all over again with the new statute. I don't know why that happened. So, questions I have is number one, where did she get that from? Number two, why did she think that was relevant at the time? Is this something that they've been doing all along? As Lawrence asked some questions that, of course, we know that those two are never going to show up on any show, on Lawrence's show. They'll show up on Fox, maybe. All right, so that was pretty much the basis of his first part of it, is that where did Kathy Azala get this stuff from? What made her think that it was okay to give to him then? What made her decide that what she had given them was the wrong thing, give him the right thing, and then really not even answer their questions as to how to interpret the new statute from the old statute, saying we don't want to get into case law or anything like that. Again, was there bias? Was there an unprofessionalism on her part? Did she need to get an attorney? A lot, and I sort of think, in my own way, is that possibly if she's very young, right out of law school, and a couple years out of law school, hey, this is what you got to go by. That someone else gave it to her. McCullough gave it to her. Someone else. But how did they even know that was the wrong one, and then they found the right one? They knew something was going on behind the scenes. So now the second part of it had to do with whether or not federal charges could be brought. Lawrence brought in a couple people. They explained things very well in terms of what is the excessive use of force. to take a look at the flaws in the process of the grand jury and how it was put together, not put together in terms of the people that were in, but in terms of how the process was put together, in terms of Zazelia, in terms of McCullough, in terms of whether or not they did the right things. The other things had to do with, what Officer Wilson would be charged on a federal offense. As Lawrence pointed out, that the New York Times pointed out that the county prosecutor just threw softball questions at everyone that agreed with Officer Wilson, but really was skeptical of those who didn't agree with him. Federal could be a lot more delicate in the sense that, hey, was there an excessive use of force? Was his hands raised? Some people said his hands was raised. Wilson said he didn't see the hands raised. Is he lying? Like I said, there were other people who said that Brown's hands were raised. So there's a whole host of types of things that the federal can come in on in terms of civil rights, in terms of unlawful use of a firearm, excessive force, et cetera, et cetera. And I think that these things need to go in because I think Wilson would be found guilty of those things. Maybe not, but at least he would have his day in court to say that, to prove that he was either completely in the right or that he was in the wrong, whether it's excessive use, manslaughter, murder in the second degree, unlawful discharge of a firearm. There's a whole host of things in there. I think that he should be charged with, and I think that the county prosecutor should be looked at too, very, very closely, because the way that Lawrence puts it is, hey, something is wrong with this. Something is wrong in the state of Denmark, so to speak. And this is why we have a Justice Department. This is why we have an Agriculture Department. So we can go into all these little areas in here and say, hey, you're really not practicing the law the way it's supposed to be doing. No, that's not how we keep food fresh in the United States. So that's why we have a Justice Department. And we know from the last 200 years to 1815, 1814, or whatever, we had laws written in the South that, blacks didn't have any power whatsoever. They didn't have any legitimacy. They didn't have any rights. Then they got some rights, but then we took them back, they were taken back away. And, this is, again, another process. As one thing that I have read with this, the process isn't why blacks are upset. It's the process is why whites are continuing to show their white rage at the fact that blacks want more progress, blacks want more jobs, want more education, want more school lunch programs, want better quality protection in terms of the police force, et cetera, et cetera. And again, I hope some federal charges can be made. If he's found not guilty, that's the way it's going to be. But the thing is, let's take a closer look at all of this. Let's have him under cross-examination. Let's have all the witnesses under cross-examination. Let's find out what really happened and what's going on. If he's acquitted after that, that's completely, that's a completely different thing than the grand jury, who's nothing wrong with the grand jury at all, but the process that they had to evaluate from was probably exceptionally flawed.